Good afternoon, Justice Venkatachaliah, and good afternoon, ladies and gentlemen, all our members and others who are tuned into this afternoon's very important lecture. While our members know the background of this lecture, for those who do not know enough about it, I may mention briefly that we hold this lecture every year to commemorate the contributions, the great values of our founder president, the first president of the India International Center, Shri Deshmukh. Normally, we've been having this lecture on his birthday in January, but this year, because of the very unusual and unforeseen circumstances, we had to defer it twice. All of us in the India International Center, in the management and all our membership, were very keen to hear Justice Venkatachaliah in the auditorium physically. But this has not been possible for reasons you will please understand. Now, a word about our founder president. It is well known, he's one of the great personalities after the attainment of freedom, a scholar, a scientist, an educationist, an economist. He was our finance minister for 6 years, deputy governor, and then governor, Reserve Bank of India. He represented the country in the IBRD and the International Monetary Fund. He was the chairman UGC, chairman of the Planning Commission, and held various other positions. He was the person who was the man behind the establishment of the India International Center in the early 1960s. He established a value system, a code of ethics, and an intellectual standard which the center has been following for all these years past, except for certain bleak periods for reasons which don't need to be mentioned. But we have kept up with his vision, with his morals, with his standards. As you all know, the Indian International Center symbolizes us as a place, intellectual fora, which permits, which enables, which encourages intellectual exchanges, and the center seeks to promote amity and understanding between different communities of the world in a calm and harmonious environment. Having said that, I would now briefly introduce you to our eminent speaker of this evening. Justice Venkatachaliah was the 25th Chief Justice of India. He retired in 1994. As it happened, I had the privilege of working with him. I was the Home Secretary at that time when he took over, but he retired a little after me. I retired. I was also concurrently the Secretary Justice. And it so happens, ironically, that my work as Secretary Justice came to a peaceful end when the 9-judge bench took a decision for the appointment of judges, the competence and the authority to stand transferred from the executive to the apex court. The Department of Justice after that has been merely a regulatory office. Earlier, we were contributing to the decision making. And I do not know whether Justice Venkatachaliah will recall that in the period that I had occasion to work with him, there were many cases which were recommended to the government, which when we examined them, we found certain problems. And whenever I had occasion to contact Justice Venkatachaliah and bring these matters to his notice, he took these things very seriously. I recall a particular occasion when two persons from the Calcutta High Court were recommended for certain positions, and I went to Justice Venkatachaliah after office hours and brought to his notice certain matters. In today's age, nobody would believe after about 3 weeks, he rang me up, he called me to his residence, and he said, withdraw these proposals. I'm not satisfied with what we had recommended earlier. So this was a period when certain things happened without any publicity, without any hoo-ha, correct decisions were taken. After retirement, Justice Venkatachaliah has been the chairman of the National Human Rights Commission. He has also been associated with certain private, non-official bodies. He is on the advisory board of the Foundation for the Restoration of National and Cultural Values. He is also associated with an organization's initiatives for the reform of government, for the improvement of government. But most of all, the various high positions he has held, I had very fond memories of working with him again when he was appointed chairperson of the National Commission to review the functioning of the Constitution of India. This was in late 99, and wonder of wonders, it never happens when national commissions are set up. He saw to it that the National Commission's report was furnished within 18 months, several volumes. I happened to have the occasion to work in one of the subsectors in governance, and a great deal of work was done. And it's a sad occasion, sad thing to say, that the recommendations of this commission, which were of fundamental importance, never got to be executed for reasons which are not far to seek. One of these was the manner in which the Prime Minister would be selected and appointed, the manner in which he could be removed. And if he were to be removed, not only the PM, the CM also, alongside you had to recommend an alternative person, substitute person, his successor. And the vote would not only be to remove the incumbent, but to also vote in the successor. So there were many seminal recommendations which I very much wish the country had had the wisdom to accept. So I would not take more time. I would now request Justice Venkatachaliah to please address us on the subject he has chosen is the Constitution of India, what it should mean today, what it should be doing today. Justice Venkatachaliah, please.
Dr. Vohra, members of the audience, I'm grateful to Dr. Vohra for the invitation to be with you this afternoon to celebrate the life of an eminent Indian. I start with a statement by Ian Tattersall, who was the curator of the American Society of Natural History. He said, the Homo sapien is not simply improved version of his ancestors, but a new concept, qualitatively distinct from them, a totally unprecedented entity. This prediction, this statement, the fruition of it we see in the great exploits of science today. Dr. Chintaman Dwarkanath Deshmukh was a charismatic personality and a visionary. After a brilliant educational career, he entered the prestigious Indian civil service and made immense contribution to the nation as an administrator, educationist, expert on economic policy. He served in various capacities as the governor of the Reserve Bank of India, finance minister of the country, member of the Planning Commission, Indian representative on the executive boards of the Bretton Woods institutions. He was the recipient of the Ramon Magsaysay Foundation Award. A scholar, administrator, economist, internationalist of great stature, Dr. Deshmukh's contribution to the nation is immeasurably immense. He was the founder president of the India International Center. I deem it an honor to be invited to speak on an occasion celebrating the memory of this eminent son of India. I am deeply grateful to Dr. Vohra, former governor, for the honor of this invitation. On the 14th of May 1787, Benjamin Franklin, who had toiled hard for 4 humid months for the Philadelphia Constitutional Convention, was waiting for the delegates to arrive. As there was delay in their arrival, he looked at the picture of the half sun painted at the top of the chair meant for George Washington. He was reminded of the difficulty of any artist in distinguishing between a rising sun and a setting sun. After the success of the convention, he remarked, "I have often and often in the course of this session and in the vicissitudes of my hopes and fears as to its issue, looked at that behind the president without being able to tell whether it was a rising or setting sun. But now at length, I have the happiness to know that it is a rising sun and not a setting sun." When the Constituent Assembly of India was completing its monumental work, it was again the metaphor of the rising sun. A great republic was reawakening to its great glory and its tryst with destiny. They were the most disturbing times of our history. More than 500,000 people lost their lives in the communal strife following partition. The deliberation of the founders was concentrated on one thing: how to secure the posterity from the scourge of communalism. The debates rose to spiritual heights. The making of the Indian Constitution was indeed a sublime spiritual event for a country with every kind of diversity: linguistic, religious, cultural, ethnic, and all of them. The choice and acceptance of the Republican model of democratic government was described as the biggest gamble in history. The vast diversity of the country was both its strength as well as its weakness. It used to be commented that India lives concurrently in several centuries, both past, present, and the future. It is also described as a great civilization in an advanced stage of decay. Indian polity was also described as a functioning anarchy. The Western press was cynical at the success of the institution of parliamentary democracy, of the Westminster model in a country with large uneducated masses. But later the same press praised the Indian democracy as robust, though it called it the rowdiest. The difficult and the most important aspect in a democracy is its demands on every citizen. It is the reason why the highest office in a democracy is that of the citizen. Government is the most potent teacher. It teaches its people decorous political behavior is another source of public education in democracy. There's an increasing discomfort that political leadership today merely emphasizes the form against the true spirit of the democratic values and is dominated by sheer political opportunism. This is a sure prescription for fall and degeneration of democracy. Democracy has endowed mankind with great riches, but it's not indestructible. If money becomes the means and the measure of man, Money is not the true measure of man, but really a measure of how small a man could be. Constitutional documents, however lofty and elevating their exhortations, do not work out by themselves. They need the instrumentalities of human agencies and institutions, system of common law, legislation, and equally importantly, constitutional conventions are the agencies and instruments. Most important is the culture of the people to obey the laws. That is the single most important factor promoting constitutionalism and respect for constitutional institutions. Political leaders have a great responsibility in that behalf. Man's capacity for justice, it is truly said, makes democracy possible. Man's inclination to injustice makes democracy necessary. Democracy is to human society what oxygen is to human life. We have taken this great miracle for granted. The remedy for the ills of democracy, is more democracy. India's constitution became historic owing to the context of its times. The Second World War had just ended. The world was appalled at the brutality witnessed during the war. The human rights philosophy came into the forefront of the debate. There were times just after the barbarism witnessed in the Second World War. Even cultured Europe had seen the rise of Hitler and how street gangs had come into the possession of the resources of a great modern state. But Hitler never ceased to boast, and that it was through popular democratic vote. The avowed objective of the founders of our constitution was to make India a secular democratic republic. Article 25, which provided for religious freedom, was enshrined in the constitution unanimously without any reservations or any hesitation or any debate. Democracy is the most precious political innovation of the human mind. The Universal Declaration of Human Rights equates democracy to a product, the result of a process of periodic free and fair elections conducted under an independent authority. That seems to me to be the minimal attributes of the democratic principle, as else it could degenerate into mere statistical interpretation of democracy. Democracy has spiritual dimensions and cultural pillars. Pluralism is one of them. Secularism is another. Fraternity is yet another. There is also an egalitarian element. You can have democracy or concentration of wealth in the hands of a few. You cannot have both, as Brandeis said. The philosophical contemplations on the significance of the broader idea of democracy are that men, incomplete by themselves, seek the ordainment of their completion and fulfillment in the company of their fellow men, and democracy provides the highest and the richest opportunities for such interaction and fulfillment. Economic development without democracy has its problems. Indeed, there are two views of development itself. One insists on growth at all costs and for its own sake, ignoring and even consciously combating anything inconsistent with such growth in the belief that it will ultimately trickle down to benefit all. There again is the famous Lee thesis, named after the legendary maker of modern Singapore, that democracy and development do not go hand in hand. The other view of development is a more friendly version, which holds that social reforms lead to economic progress and not economic reforms to social progress. The report of the Sarkozy-appointed Commission on Measurement of Economic Performance and Social Progress, on which nearly 3 Nobel laureates work, raises the issue of the inadequacy of the GDP as a tool of measurement. Human Development Report described such growth for its own sake as ruthless, voiceless, jobless, and futureless growth. Ladies and gentlemen, no constitutional document is frozen in time or etched in granite. A constitution, in the famous words of Chief Justice Marshall, is framed for ages to come to respond to the needs of an expanding future and to approach immortality as nearly as human institution can approach. There are similar thoughts expressed by great judges on how a constitutional document is to be read, understood, and expounded. In the interpretation of the constitutional document, words are but the framework of concepts, and concepts may change more than the words themselves. The intention of a constitution is rather to outline principles than to engrave details. The words in a constitutional document are empty vessels into which anything could be poured according to the needs of the time. As Justice Frankfurter reminded us, constitutional law cannot be confined to mere words of the Constitution, disregarding the gloss life has written upon them. Constitutional idiom has a purposed vagueness, to leave room for the unfolding future. We must never forget, so goes the judicial wisdom, that it is the Constitution we are expounding, intended to endure for ages and to be adopted to the various crises of human affairs. The great generalities of the Constitution have a content and significance that vary from age to age. A nation needs to grow as it expands. Formal constitutional amendments usher in sweeping changes, but courts achieve the same softly and gradually, often indirectly, by well-considered steps to enable the past to join the future without strife in the present. The task of the courts is not merely to find the meaning of the words, but also to supply new meaning to the words themselves. Ladies and gentlemen, what then are our expectations by way of constitutional responses to the crisis of our political life and economic predicament of our times? The manifestations of discontent are evident. There is an air of irreverence to values and to institutions. There is an increasing air of distrust, cynicism. Cynicism is a power of destruction, not a power of reconstruction. Dr. Ambedkar's caution in the Constituent Assembly has now acquired a new urgency. He warned us, if we wish, I quote, if we wish to maintain democracy not merely in form, but also in fact, what must we do? What must we do? The first thing in my judgment we must do is to hold fast to constitutional methods of achieving our social and economic objectives. It means we must abandon the bloody methods of revolution. It means that we must abandon the method of civil disobedience, non-cooperation, and satyagraha. When there was no way left for constitutional methods for achieving economic and social objectives, there was a great deal of justification for unconstitutional methods. But where constitutional methods are open, there can be no justification for these unconstitutional methods. These methods are nothing but the grammar of anarchy, and the sooner they are abandoned, the better for us. It has a contemporary ring. This warning has a contemporary ring. Idea of secularism, as variously propounded, has raised more problems than solutions. A page from American history is worth recalling. In 1844, the Supreme Court of the United States of America declared that Christian religion is a part of the common law of America. The court yet again in 1892 said that this is a Christian country and a Christian nation. Bernard Schwartz spoke of how in just 30 years thereafter, in the famous case of John T. Scope, that was popularly called the monkey trial, severed that link between law and Christianity. Scope's trial, as we know, was a prosecution of a teacher who taught Darwinism, Darwinian evolution, which violated a state of Tennessee's law proscribing propagation of any theory which denies the divine creation of man as taught in the Bible. But the debate between evolution and creationism lingers on. I recall the beautiful words of a former Prime Minister of England, John Major, who described in very emotive terms of the British Constitution. He said the British Constitution is vibrant and robust, but it's not indestructible. It's not a piece of architecture that one can re-engineer by knocking down a wall here and adding an extension there. It is a living and breathing constitution. Its roots are ancient, but it has evolved. It embodies a set of values, a legacy of understanding that have developed year by year over the centuries. No one should lightly contemplate tampering with an institution that is so ancient and yet so alive. This is a caution for meaningless amendments suggested for all trivial purposes. Political parties are the medium through which the objectives of a democratic polity are pursued. They are the only way thus far invented by the wit of the Western world, which with some effectiveness can generate countervailing collective power of the many individually powerless against the powerful. Representative or indirect democracies have the inbuilt ideas of microcosm and a filter. Volatile, raw public opinion is refined through the electoral process, but then a representative democracy must approximate as nearly as possible to the image of the society it seeks to represent. Elections are a mode of such expression of the will of the people. A parliamentary democracy requires representative government which will truly reflect the public opinion, or what John Stuart Mill called the general will of the people. An ideal democracy is one which functions in consonance with the public opinion. In order to ensure this, election should be free, fair, and meaningful. Institution of parliament is again the product of the great political sagacity and innovation of the human genius. In Britain, parliamentary supremacy is supposed to be the symbol of the political sovereign, the people. Herbert Spencer recalled how the superstition of the divine right of kings was substituted by the superstition of the divine right of parliament. Constitutions with inbuilt bills of rights place certain liberties of the people above the parliaments and not subject to the result of any election. The Human Rights Act of 1998 in England, while retaining the doctrine of parliamentary supremacy, has provided a declarative remedy for the alleged violations of the rights under the European Human Rights Convention. But the biggest dilemma is what happens if the political system is corrupt. If the political system, the electoral system itself is corrupt. John Stuart Mill lamented, I quote, "Of what avail is the most broadly popular representative system if the electors do not care to choose the best member of parliament, but choose him who will spend most money to be elected? How can a representative assembly work for good if its members can be bought or sold, if their excitability of temperament, uncorrected by public discipline or private self-control, makes them incapable of calm deliberation, and they resort to manual violence on the floor of the house or shoot at one another with rifles?" This is what the caution of John Stuart Mill. There is presently no substantial plenary legislation dealing with the formation and functioning of political parties. There are I have mentioned the relevant rules which have a bearing on that. There are said to be about 1,600 registered political parties. Some of them indeed, or many of them, do not seem to be really concerned with political engagement. Some exist to pursue other interests. the corruption in elections are closely linked to the ethical standards of political parties. Supreme Court has, from time to time, issued specific directions to sustain the purity of the electoral process. A year ago, it directed the political parties to upload on their websites information pertaining to individuals against whom criminal cases are pending and who are likely to be presented to the public as candidates for the elections. It was on record that while in 2004, 24% of the members of parliament had criminal charges pending against them, which went up to 43% in the elections in 2019. Quality of men elected gradually deteriorates. Over time, voters succumb to the din and bustle of the electoral campaign and produce either a dictator or an insensitive or a dumb politician. And there is thus a tendency towards democratic fatigue, and the cry for a strong leader emerges. There is thus a democratic fatigue, and the cry for a strong leader emerges. The quality of elected men gradually has deteriorated in the country. We may all recall how a well-known economist lost his election. A known economist who later became the prime minister of the country lost his election but in a different constituency elsewhere. A person who was described as a bandit, she got elected. And these are the enigmas of the electoral process. Ladies and gentlemen, as the Law Commission once remarked, and this is exactly what the Vohra committee report concentrated upon, that instead of politicians having suspected links to criminal networks, as the case was earlier, it was persons with extensive criminal background began entering politics themselves. A discussion paper issued by the Center for Standards in Public Life, of which I happen to be the chairperson, strongly argued that there is an imperative need for electoral reforms to ensure free and fair elections in the real sense, to make elections more meaningful and reflective of the will of the people. It was also argued for a comprehensive law regulating the registration and functioning of political parties and the alliances of parties, and dealing with the institutionalization of political parties, their formation, party organization, and inner party democracy, party funding, maintenance of accounts, and auditing, ensuring transparency and adherence to certain basic norms and requirements on pain of derecognition and deregistration. Many countries have such laws regulating the affairs of political outfits. A 2002 pronouncement of the Apex Court has made derecognition virtually impossible unless the registration itself was obtained by fraud, forgery, or misrepresentation. Ladies and gentlemen, the sovereign prerogative of I'm speaking of the political need for political stability and a fixed term of parliament, of which President of the meeting, Dr. Vohra, spoke during his introduction. The sovereign's prerogative power of dissolution of parliament to be exercised on the advice of the prime minister, and the prime minister's right to seek dissolution and get a general election have been two of the key features of the Westminster model. These conventions are also part of our constitutional law. This long-established constitutional position in UK has been consigned to constitutional history with the passing of the Fixed Term Parliament Act of 2011. Under the new enactment, the term of the parliament is fixed. Even the dates of successive general elections are determined as the first Thursday of first Thursday of May of every 5 years. According to the next immediate poll after the new enactment was set and held on Thursday, May 7, 2015. The Prime Minister can provide by a statutory instrument that the scheduled poll be delayed by up to 2 months, justifiable in the case of some emergency. An early general election would be possible at any time only if the House of Commons, by a majority of at least 2/3 of its total membership, votes for that, or if the House passes a vote of no confidence in the government, which vote is not reversed within 14 days. The gap of 14 days is to provide for the possibility of a new government taking office without the need for an election. These are only exceptions to the prefixed polling dates. Should India consider any such reform? The malady of hung legislatures and the uncertainty of coalition politics and governments are very well known. Many a time, the whole system is brought to a halt. The Prime Minister or the Chief Minister, as the case may be, is reduced to less than a figurehead, and parliamentary democracy becomes farcical. Everything other than national or public interest is the compelling factor. The term of the lower house is fixed by the Constitution as 5 years, unless dissolved earlier. Such earlier dissolution is occasioned generally by bringing down a government. We saw between 1995 and 2000, I think, there are 3 general elections in this country. The National Commission to Review the Working of the Constitution recommended in 2002 that the leader of the House be elected along with the Speaker in like manner, and the person so elected be appointed as Prime Minister, Chief Minister, as the case may be, and that any motion of no confidence against the government should have the support of at least 20% of the total membership of the House, and it should be accompanied by a proposal for an alternative leader to be voted simultaneously. This is on the lines of the German Constitution and also suggested by Paskiwala in September 1979 while delivering the Madras University convocation address. This can be achieved without amending the Constitution by evolving conventions about the entire House, electing the person to be appointed as Prime Minister, the Chief Minister, as the case may be, and by appropriately amending the relevant rules of procedure and conduct of business as regards a no confidence motion. The basic postulate of parliamentary system, accountability and ministerial responsibility, would be kept inviolate while imparting greater stability to government. In the present scenario, it would be preeminently worthwhile to consider this. All this has been said before. The lament is that it had to be said again and again because nobody seems to listen. Not that these proposals should be accepted straight away, but there must be a healthy debate over them. And the lack of political engagement on such serious issues is the biggest problem. It is not the solution that anybody is sure of, but a discussion. That's the essence of democratic process. Ladies and gentlemen, some 30 years ago, the Law Commission of India circulated a consultation paper which contained a suggestion for the bifurcation of the nation's apex court into a constitutional court and a court of appeal, a pattern familiar in the civil law jurisdictions. The proposal was considered by a committee of judges of the Supreme Court. I was a member of that committee. The committee was the opinion that in the common law jurisdiction, such watertight compartmentalization was not possible, as the two jurisdictions, civil and constitutional, have overlapping areas, and many civil law issues admit of being expressed in constitutional values, in terms of constitutional values, and a strict bifurcation was not practicable. An organic bifurcation was not a possibility in the common law system. However, in the matter of working, it was considered desirable to have a constitutional court as a distinct functional entity. And the judges of the divisions, constitutional division and the appellate divisions, are interchangeable under the same Chief Justice. That functional arrangement would emphasize the importance of the primary concern as the apex court of the nation for constitutional adjudications. Justice Frankfurter, sitting in the American Supreme Court, cautioned the court that it is not a Supreme Court of every case decided unjustly in the country. He said it is not a Supreme Court of every case decided unjustly by every court in the country. The court may be doing justice in the four insignificant cases it decided today, he said. It's certainly doing injustice to the significant important cases on the calendar and to its own role as supreme judicial body in the country. Judicial reflection is a process that requires time and freedom from pressure of having more work to do than can be well done. Judicial reflection is a process that requires time and freedom from pressure of having more work to do than can be well done. This can be a message to the Indian Supreme Court also. As of now, there are 3.67 lakh cases in the subordinate courts in the country. 70% of them are criminal cases. There is a dramatic reversal of this proportion between civil and criminal cases in the 15,70,000 and not pending cases in the High Court, where criminal cases account for only 30%. Case flow management should become professional and technology assisted. That is one of the main demands of the times for reforming the judicial system. The advocacy paper on the rule of law for the 20th century, issued by the Foundation for Democratic Reform, contains very useful comparative information and statistics about judicial infrastructure in the country. World Justice Report Project Rule of Law Index places India at 69th place out of 128 countries. There are some interesting statistics that are worth noticing. The expenditure on rule of law as a percentage of the GDP, expenditure on the rule of law as a percentage of the GDP is almost 2% in the United States of America. 2% in the United States of America. 1.83% in the United Kingdom. It is 1.56% in Germany. But in India, it is 0.76% in India. Police force for lack of population is 238 in the US. It is 156 in India, and in Germany it is 388. Of forensic labs, there are 409 forensic laboratories in the United States of America, while India, which has 4 times that population, have only 37 of them. Number of samples tested in a year in criminal cases is 12 lakhs in the United States and 20,000 in India. Number of incoming civil cases annually for 1 lakh population, how many new cases are filed is one of the index of civilization. It is 5,200 in the United States, 3,455 in the United Kingdom, and 257 in India. India is under-litigated. There's no docket explosion, but there seems to be a docket exclusion. For 1 lakh of population in the United States, 5,200 people come to court seeking remedy in civil cases, while it is only 257. There is no further need to comment on the gross inadequacy of the judicial infrastructure in the country and the urgency of reform. I end this talk with an epilogue. I called it, "O Lord, make me holy, but not today." O Lord, make me holy, but not today. At the end of the 200 years of the American Constitution, a non-governmental group consisting of 200 eminent Americans, former governors, ambassadors, diplomats, academicians, public men, took upon themselves to review the working of the American Constitution and came up with a report titled Reforming American Government. One paper titled Grass is Greener on the Other Side fondly looked at the parliamentary system. Today, in the context of the near explosion of disruptive technologies and the trend towards ethic-neutral civilizational transformational influence, it is necessary to foresee as far as possible the potential for imminent civilizational decay. Will Durant called civilization a social order which promoted cultural creation. 4 elements constituted: economic provision, political organization, moral traditions, and the pursuit of knowledge and the arts. It begins, he said, where chaos and insecurity end. For when fear is overcome, curiosity and constructiveness are free, promoting the natural impulse towards the understanding and embellishment of life. In every age, even after everything contentious and debatable is taken out of the way, there yet remains a remarkably wide and firm unanimity as to what is fair, what is just, what is good, and what is beautiful. After we eliminate all the debatable items, there are still a set of values which can be identified through the values of truth, beauty, and goodness. If wielders of power ignore this, divergence becomes marked and they fall out of respect. Raymond Kurzweil believes that a moment will arise when computers will become intelligent, and not just intelligent, but more intelligent than humans. When that happens, our bodies, our minds, our civilization will be completely and irreversibly transformed. He believes that this moment is not only inevitable, but it is imminent. Though we have seen in history, though men have been amazingly creative in science and technology, they are amazingly non-creative in finding solutions for some of the deepest morally sensitive issues of human survival. The extraordinary exploits of science and technology will create unequal societies with concentration of wealth and power in the hands of a few. The new technologies may even compel political, social, economic systems to change and to adapt to the demands of their own technological prescriptions. It is for the leaders of public opinion to decide whether a standing national watchdog body, a civilizational sentinel, may call it by whatever name, to act as the collective conscience of mankind, to retain faith in the liberal story, and against a possible digital dictatorship, to preserve the never-fading fragrance of what humanity has always cherished as truth, beauty, and goodness that adds savor to human life itself. On this, I must say what Augustine said about us, about humankind. O Lord, make me holy, but not today. Thank you very much for your patience and courtesy. Thank you.
Thank you, Justice Venkatachaliah, for an extremely important address which covers the entire spectrum of the concept of democracy, concept of secularism, the foundations of executive governance, the quality of the polity, the lack of regulation in internal democracy among political parties, that economic growth is not social progress, the challenges to our constitution as of today, and the unfortunate fact that constitutional methods are not being followed, are not being practiced to achieve the attainment of our social and economic goals. And this, as Justice Venkatachaliah said, the non-adherence to constitutional methods is the grammar of anarchy. He has spoken to us at length about the roots and foundations of secularism and the context of our Indian constitution about communalism, the great bloodshed, the arson, loot, and death which had preceded the Independence Day. That was in the minds of our founding fathers, and not merely a simple word in English, secularism. There's a great deal of history and meaning behind it. Corruption in the political system and the electoral system, we have been talking about it for decades now, and Justice Venkatachaliah has told us what can be done, what should be done, and what should have been done. Over 1,600 political parties, as many as 43% of our parliamentarians have criminal cases pending against them. This was always so, but the percentage of those who had something questionable in their background was a small percentage when we started the electoral system. And he has spoken to us what possibly could have happened in terms of democratic fatigue and the circumstantial urge to look for strong leadership. And the process, again, perhaps bypass the constitutional norms. And what dangers lie ahead if we allow ourselves to be sucked in by the problems, the dangers of democratic fatigue. The high importance of electoral reforms and the crucial importance of political and governmental stability. Political stability should be there, only then the governance can be stable, meaningful, and effective. And he has told us how, in the recommendations of the National Commission for the Review of the Constitution of India, two crucial recommendations were made. One, that the Prime Minister and the Chief Minister of States should be elected in the House. The leader of the House should be elected by the House along with the Speaker. Once elected as Prime Minister, once selected and appointed as Prime Minister, that person cannot be removed except when 20% of the entire strength of the House put their signatures to the proposition to his removal. But that alone is not feasible. They would also have to recommend the name of the successor. And the voting on the ousting of the incumbent and the selection of the successor would be done at the same time simultaneously. Now, these recommendations were put aside, as mostly happens, and Justice Venkatachaliah has once again referred to the need for a meaningful, purposeful debate. He has not said that do it overnight, but engage in a purposeful debate, and all this will not require any constitutional amendment. That is the remarkable part of these recommendations. Reform of the judicial system, rule of law. He has referred to what the country does in terms of administration of justice. There are enormous logistical failures in terms of lack of capacities, lack of infrastructure, and he has given us the figures in America and India of how many people seek civil redress in American courts and how many do in India. There is no law of torts, there is no compensatory system. People suffer, they keep on complaining, and there is no redress. The fact that now India stands at the 69th position out of 128 countries which were assessed in terms of its standing in the rule of law is a very poor reflection on how far we have traveled after 72, 73 years of independence. So I think, among other things which we need to do to stabilize the polity and stabilize governance, would be one of the high priorities will be to restore the rule of law, the rule of the constitution, and that would also, by implication, ensure that constitutional methods are followed by executive and other organs to achieve the objectives of governance, the social objective, the economic objectives. And in terms of government spending on the justice system and upholding of the rule of law, we spend only 0.07% of our GDP. That itself shows the kind of importance that we should have given to this particular task and how exactly we have gone about it in terms of neglect. While speaking of this figure, I may mention in passing that while we have several lakh civil police in the country, district police, civil police, not the armed police, for the enforcement of the rule of law, the per capita spending on the constabulary is ₹3 a day. So you can imagine what kind of constabulary we have, what kind of discipline, what kind of motivation, what kind of morale, how we treat them, what we pay them, and what do we expect them to do. So there's a large field which Justice Venkatachaliah has covered. I'm only mentioning some of the things in his lecture, very meaningful and important lecture. I wish we were all there physically to hear him in the IIC auditorium today and to remember our founding president. So having said that, Justice Venkatachaliah, please allow me to thank you for your very graciously agreeing to deliver this lecture and to do so today from Bangalore. Thank you very much.